Whenever you're ready, Marianne.
Okay, thank you. Welcome to the American Society of International Law Intellectual Property Law Interest Group webinar on current issues in intellectual property and artificial intelligence. This has been, needless to say, a very hot topic in recent months with the publication of the National Security Memorandum on artificial intelligence a couple of days ago out of the White House. You can find it on whitehouse.gov. And with the awarding of the Nobel Prize in Physics to Professor Hinton, two of his colleagues, for artificial intelligence, his work on artificial intelligence. And I mentioned Professor Hinton because in a recent interview, he said the following: the Industrial Revolution made human strength irrelevant, and the artificial intelligence revolution will make artificial intelligence revolution will make human intelligence irrelevant. So with that kickoff, we would like to welcome our panelists, Kerri Braun, who is Senior Corporate Counsel, Trade Secrets and Copyrights for Cisco Systems Incorporated. She is responsible for Cisco's Global Trade Secret Protection Program and Copyright Program and Registry, while supporting the entire legal group in trade secret and copyright matters generally. Following her will be John Hines, who works with clients seeking to realize value from IP, technology, data, and other information and software technology assets through licenses, joint ventures, M&A, and cloud and other technology services agreements. He regularly counsels clients on their rights under the Copyright Act, and in that context, helps clients navigate the use and disposition of emerging technologies in various development, acquisition, and licensing projects. John also provides IP litigation support and assists clients in resolving copyright and contract disputes pertaining to rights allocations and infringements. And Joe Petersen. Joe Petersen is the managing partner at the Kilpatrick, Townsend, and Stockton LLP's Silicon Valley office. He's a partner with more than 2 decades of experience representing a broad array of clients in litigation, arbitration, and administrative proceedings involving copyright and trademark law. Mr. Petersen also frequently advises clients on how to mitigate litigation risk and creatively seeks to find solutions to disputes. He frequently speaks on copyright and trademark issues before national organizations and routinely advises legal publications on cutting-edge copyright issues. We would like to begin with Kerri Braun. Kerri, please go ahead.
Thank you so much for having us to talk about this exciting topic. The panelists thought it would be a good starting point to do a little bit of table setting. So when you're looking at intellectual property issues that are unique to nascent generative AI technology, which is what this panel will be discussing, it's important to first understand whether or not you're actually dealing with generative AI, or rather merely with regular artificial intelligence, which we've been dealing with since the 50s. So definitions can be very meaningful, especially when you're trying to scope your advice that you're giving to a client, for example, or whether you're negotiating the terms of a contract. So when you're looking for definitions of artificial intelligence or generative artificial intelligence, it's instructive to look at established laws or other authoritative sources. So I'll start with, what is artificial intelligence? A layman's definition usually sounds something like this: it's a set of technologies that enable computers to perform functions normally performed by humans. Now, if we look to a legal definition, we have 13 USC 35021. And that says artificial intelligence is a machine-based system that can, for a given set of human-defined objectives, make predictions, recommendations, or decisions influencing real or virtual environments. Artificial intelligence systems use machine and human-based inputs to perceive real and virtual environments, abstract such perceptions into models through analysis in an automated manner, and use model inference to formulate options for information or action. So I think, in other words, they perform functions normally performed by humans. So an example of this would be a spell checker that compares a paragraph with a database of words and highlights the words that may be misspelled and displays a possible spelling that might be correct. Or you can search for the word cat in your cell phone and your photographs, and it will show you pictures of cats. So that's artificial intelligence. Now, what is generative artificial intelligence? This is the new thing that's come on the scene in the last several years that everyone is talking about. So for this one, I have an example of what the EU Commission has used in the EU AI Act. This says that generative AI systems are a specific subset of foundational models specifically intended to generate, with varying levels of autonomy, content such as complex text, images, audio, or video. And you can look at examples of other definitions from organizations like the IAPP, for example, or in Biden's executive order on the safe, secure, and trustworthy development and use of artificial intelligence. So an example of generative AI is you can put a prompt. So you enter information into ChatGPT asking for an example of a corporate policy for an employee's use of Gen AI. And this prompt would yield an example of a policy. So it would draft the policy. So our group, again, will be highlighting unique intellectual property issues, including cases and mitigation techniques that arise when using generative AI. So when evaluating various Gen AI risks, I always think it's helpful to look at generative AI use cases as a set of work streams, with tool creators and providers on one side of the equation and users on the other side. So let me explain what I mean by work streams. Starting with the first work stream, we have model creation. This base model creation is performed by companies, tech companies like OpenAI and Microsoft, for example. And this involves gathering vast amounts of data, sometimes through web scraping of publicly available information on the internet, pre-processing it so that it's easier to use. So that means deduplicating or transforming it into a format that's easier to ingest, and then ingesting that information, feeding it into the model for training purposes. And many will argue that this involves some form of copying. The model makes comparisons between the data and draws inferences that allow it to make predictions that enable the machine to create content. So gathering data and training. So that's model creation, the first work stream. The second one is fine-tuning, alignment, and other operations that might influence the output of the model or the accuracy of the output or other functionality of the model. So this work stream can take place multiple times and in multiple points in time throughout the process. So it can be done over and over. It can be done after an end user uses the product. So I like to list this one next because usually it's the model creator or the provider that does this, but it can happen at any phase. Now, on the other side of the equation, we have the end user. So the first work stream is the input phase. So the user, as the name suggests, inputs information or content into the tool to elicit a certain output. So the art of creating a prompt that elicits certain types or quality of responses from the Gen AI tool is prompt engineering. So prompt engineering, what you input can give rise to certain issues. And then the final part or the final work stream we'll look at is the output. So the output is the Gen AI tool's response or the material created like a picture, song, movie, text, etc., in response to the inputted prompt. So now that we're looking at this in somewhat of a linear format, and we can see the progression of the work streams, we can start to see how each phase gives rise to certain unique IP issues. So we're going to delve into the bodies of law that might be invoked by the creation or use of Gen AI tools now. So with that, I'm going to hand it over to John to talk a little bit more about the law.
Yeah, thanks, Kerri. That's great. We're going to start with a little bit on copyright. Copyright is truly where a lot of the action is, for reasons you may have intimated from Kerri's discussion. And the Copyright Office's action really started with the issuance of a notice of inquiry, which is a marvelous document that asks a lot of open-ended questions to the world about what they think about content, what they think about artificial intelligence. It's a should document that sort of asks what the law should be and what the law is. And there were many, many responses from academics, business, many different stakeholders, and I really encourage you, all to take a peek at that. Interestingly, the first report following the assemblage of the materials by the Copyright Office came with a recommendation not for copyright legislation, but legislation dealing with digital replicas, which are essentially replicas of human beings that are essentially deep fakes of human beings. It sort of overlaps with rights of publicity, but goes much further. And we may want to talk about that a little bit later. But the real action has been in the copyright arena with the cases and a lot of litigation. And what I want to just kind of start at a very general level talking about is how the Copyright Act interfaces with artificial intelligence. And it's great to keep in mind Kerri's model there with the training of the model, the input by the user into the model, and ultimately the output of the model. And the areas that are at the pinch point of copyright action are really at the training level, because as Kerri pointed out, there are people grabbing a lot of data from everywhere and inputting it into the model. And then at the output level, who owns it? Is there a copyright ownership in the picture that's generated? And just to back up a little bit quickly on sort of the fundamentals of copyright law, and I'm anticipating Joe may give us a little more insight into some of the cases, but generally speaking, the copyright, unlike patents, unlike trademarks, who have their own intellectual property protections, ideas, and source identification, respectively, copyright protects expression, not ideas. It's the presentational qualities, the selection and coordination of fixed perceptible data. And the purpose of the Copyright Act is to increase authorship, not authors, but authorship, increase expression. And the Act calls out the embodiments of different types of expressions: literary, written works, musical, dramatic works, etc. And the idea of the copyright law to incentivize authorship is to give a monopoly on original expression for a limited time that gives the owner of the rights the right to exploit that original expression, and that those rights are just about anything you can do with text or music is copy it, publicly perform it, publicly display it, distribute it, and create derivative works, meaning create something new but based on the protected work. So that, in a nutshell, is copyright. And so if you do those things, is there a defense? And the answer is yes. The Copyright Act allows certain breathing room for public interest and free speech. And it looks primarily to how, if we're going to give that breathing exception, that breathing room, is the use transformative? Is it something new? Is it something different than the original work? And does it affect the existing market for the original work? Probably those two things, although there are multiple factors. That's the key, is does it affect the marketplace, and is it something new? So back to the life cycle, how does copyright interface with the Act? Well, when these people go out and grab all this data and touch it, it touches probably the exclusive right to copy, and in funneling that data into the model. And here, just again, to go a little bit deeper into the model creation, it's important to ask, well, what is really being done here? Are we really using the expression? Are we really threatening the expression of the copyright holder? And and I'm going back a little bit to Kerri's emphasis on the idea of prediction. What really is happening is when we train a model is we convert the model is nothing but a set itself of numbers of parameters and weights, and the inputs, the data that is input is turned in essentially to numbers and tokens. And a question arises as to whether it has anything to do with expressive content, or whether we're in effect, just extracting unprotected expression, unprotected information about the English language, instead of using the English language to, mimic some other expressive content. So based on the weights and measures that are created in the model, the user will input something, let's call it a question, input something into the model, and that question itself will be converted into data, a data token, looking for statistical correlations between other tokenized data in the model to make a prediction. So that's sort of number one. And then the question is, does that activity, that physicality that we've just described, amount to or lead to any kind of copyright infringement? Or is there a fair use defense? Does it threaten the market? Is it transformative? And we'll get into those questions. The other area where the AI comes into contact, interfaces with the Copyright Act, is at the output level, which is is that picture that's created, is that piece of text that's created, that letter that's created, that play that you create, whatever, is that subject itself to copyright protection? Is it owned, or is it something that sort of immediately falls into the public domain absent some other kind of protection? And the Copyright Act is very, very clear that, as interpreted, that the creation has to be human created. For example, there's a great case dealing with a monkey creating a selfie with an iPhone, and the picture that was created was very clearly determined to be not protectable under the Copyright Act because it was not created by a human being. Well, that also applies to machines as well, and to computers and to artificial intelligence. But it kind of begs the question, if there is human involvement, the prompting, for example, or some extensive amount of prompting, or back and forth query and answer with the artificial intelligence solution, is that sufficient to create a human created work that would be protected by the Copyright Act? And I won't go into the details of the cases. Right now, the Copyright Office is, I would say, very cautious about it. It doesn't look, I would say, with open arms to the idea that merely multiple back and forth in a prompt, or some kind of selection of weights and measures by the user, some sort of tweaking of a knob here and there, is sufficient to give ownership or give the appellation of human creation to it. It's not that easy. And in fact, our copyright office requires disclaimer of the use of artificial intelligence. And the way the cases are kind of splitting up, or the two big concepts here that are being emphasized, are the lawyers representing the creators, the folks that have input the prompts and have these beautiful creations with the help of artificial intelligence, are stressing the idea of assistive technology, that the AI is merely a tool, that I've made every artistic creation involves choice. Photographs are made with a tool, but there are a myriad of choices by the photographer. And that idea of choice is central to those who are emphasizing ownership of, by the creator. And then the Copyright Office and others emphasize the technology, that the technology is truly one that, that is predictive, and it's not the human creator that is making those predictions. It is the technology. And so that's kind of the dividing line. And, maybe we'll get a little bit deeper into some of the cases if we have time, but I'm going to turn it over to Joe now.
Hey, thanks, John. So I got interested in this subject. I represented the universities that partnered with Google and were ultimately sued by a group of authors in the Google Books case. And in connection with that case, part of my job was to work with data scientists to kind of illustrate all of the advances that could be had from having a very large digital corpus. And this is about 12 years ago now. And it was really kind of eye-opening to see kind of what they were working on and then hearing them talk about the future. And it was actually right around the time I'm originally from New York. I practiced in New York. You see the Brooklyn Bridge behind me. It was right about the time that I moved out to Silicon Valley, and I've been out here ever since. And I kind of feel like I have a bird's eye seat in all the developments that are going on. And it's truly astonishing and transformative, I think, in both the copyright use of that term and also just in the technological use of that term. As a lot of you know and have probably been following to varying degrees, this technology, like all technologies before it, that generate content or work with content, has spawned lots and lots of litigation. And I used to have a count when I was talking on this subject, and it went from 10 to 20. Now it's over 30. And frankly, I stopped counting all the cases. The cases are all pre-trial. There was one case that was about to go to trial in August. That's the Thomson Reuters v. Ross case. And Copyright Bar was kind of eagerly awaiting that trial. And then the judge postponed the trial and is hearing new summary judgment briefing. All the other cases were at kind of the motion to dismiss stage. There were some rulings on motions to dismiss, and now they're in discovery. And so I think we're years out from getting anything definitive about the copyright issues on Gen AI. But we can already kind of see where the cases are going and what the core issues, are emerging, and in part because there have been lots and lots of claims brought in these cases, and most of which have been the subject of motions to dismiss. And we kind of see how courts have been dealing with that motion practice. If I had to put it in buckets, you see claims, and Kerri talked about this, and John talked about this. You see claims addressed to use of in copyright material to train a model. So that's kind of an input related claim and a claim of copyright infringement. I'm told theoretically there's a way to train a model without actually copying any works. But I think in practice, the way it's done for lots of reasons is a work is copied, loaded into the system, tokenized, and then the model, once it's trained, doesn't need it anymore, but there is a copy made. And so the question becomes, is that copyright infringement? Or as John alluded to, does the fair use defense immunize the model developers from claims? To me, that's and I'm going to go into it in more detail in a moment, but to me, that's the big ticket issue in these cases. The other types of claims that have been brought are claims that the models themselves are infringing derivative works because they were derived from in-copyright material. So I'm going to talk in a moment about what the courts have done to those types of claims. The third types of claims relate to the output of the models. And there's been some particularly in the first wave of complaints, very sweeping statements that essentially says that every output is an infringing copy of the material used to train the model. And so I'm going to talk a little bit about what courts have done with those types of claims. And then the other significant claims that you see brought in this area relate to DMCA claims for removal of copyright management information. And courts have already, I think, given a very clear indication of the fate of those types of claims. So looping back to the first question, and in my mind, the largest issue and the big ticket item is the use of unlicensed in-copyright material to train a model, is that copyright infringement? And as John said, that core issue will turn on fair use, just as it did in the Google Books case, where the universities first and then ultimately Google prevailed that copying in-copyright material for purposes of facilitating search was a fair use. There are 4 fair use factors, but not all are created equal. Really, the first factor typically is the most significant, but occasionally, and not to get too far down the line, you sometimes see factor 4, which is the market harm factor, take prominence, as it did in the recent Supreme Court decision in Warhol. So it's usually a battle on these types of issues between factor 1, which looks at the nature and character of the use, and namely, is it a transformative use? And also factor 4, is there a market harm? For these types of cases involving kind of new uses and new technology, the other 2 factors, the nature of the work, whether it's fictional or whether it's factual, and the amount and substantiality of the portions used, they are not really drivers. If you had to do an algorithm to see what the drivers are in these cases, factors 2 and 3 are not the drivers. It's really factor 1 and factor 4 that tends to be the driver. And if you read these decisions and you skip ahead, and if I see a court focusing on factor 4, my immediate reaction is this does not look good for the defendant. And instead, if you see the courts really focusing on factor 1, you think, wow, this could come out well for the defendant. And you saw that in the Supreme Court in the Oracle case, where that came out well for the use and finding a fair use. And then in Warhol, you see more of a focus on market harm. So the interesting thing, and John was talking a bit about this, on the fair use question, on the transformative use question, I think there is a real threshold issue, as John said, as to whether or not they're taking copyrightable expression. I think there's a very strong argument that really they're taking the ideas, the representations and the relationships of words and tokens much more than taking copyrighted expression. So from my standpoint, and you can tell from my background and having represented the universities and the work that I do and being based in Silicon Valley, you can kind of take my perspective on it. But I think the arguments that that's a transformative use are really, really compelling. And it taps into case law about uses that are intermediate to creating a new work. And I think there's very strong arguments that these are intermediate uses that result in the creation of an entirely different work. So that is the largest issue in these cases. It will take a fair amount of time to resolve. I think ultimately you're going to see courts let this go to juries. You're going to have appeals. You're going to have circuit splits. And in my view, it's highly likely that this ultimately gets resolved by the Supreme Court, but not for another 3 to 5 years. So there's going to be lots of fodder for debate and discussion in this area. The case that was closest to actually getting to trial was, as I said at the start, was the Thomson Reuters v. Ross case. That was slated to go to trial the end of August. And then it was marked off the trial calendar, and now we have summary judgment briefing. Judge Beep is sitting by special designation in that case. And his summary judgment ruling, I think, was a very interesting ruling where the judge, if you read that ruling, the judge did seem to accept that if all that the defendant Ross was doing was training a model to create new expression that had a very strong claim to transformative use and fair use, and the judge found issues of fact because it was unclear whether the expression, the output, was infringing. And so that's an interesting case and very much one to watch. The other issues, as I framed at the start, whether the models themselves are infringing derivative works. Courts have been hostile to those claims, with one exception, which I'll get to in a moment. And the hostility is really that the models are not derivative works. They don't contain typically anything similar to the works that were used in the training data set. They are algorithms and weights. And so since they don't contain copyrighted works, courts have been dismissing those types of claims at the motion to dismiss stage. The one exception to that is in the image generating cases. There was some comments and testimony from some of the developers that the algorithm is essentially a compression algorithm and contains all of the images. Now, I'm not sure from a technology standpoint what that means from in terms of copyright law or how factually what will come out of those cases. But those types of statements were enough to cause the courts for those types of cases not to dismiss claims against the models as infringing derivative works. And the other types of claims, and you saw this in the earlier cases, and I think that they have addressed this in some of the amended complaints that were filed in the wake of motions to dismiss, but there were claims, very broad claims, that all of the output is infringing because it was based in, at least in part, on in copyright material training data sets. And courts rejected those types of claims because they kind of lack specificity for the most part. And there are also, in some of these cases, claims that some of the output was infringing. You all might have seen pictures of the Getty soccer players, and then the output of the model had kind of an altered Getty watermark on it. And so there are claims that some of the output can be infringing. I think in those cases, ultimately what's going to happen is going to turn on volitional conduct. Like, who is responsible for that infringing output? Was it the model developer or the user that entered the prompts? And that's going to be a very key distinction, and one that I think will get fleshed out. I personally don't think that's one that needs kind of a change in the law. I think we've got very well-developed rules around volitional conduct and secondary liability, but there's super interesting issues around that, principally because for two reasons. One is there are times when the data sets that were used have many duplicates. And in that case, it's easier to generate an infringing output because the model was trained on the same type of image. I think with time, that problem is going to go away. And the other issue is one of the broadest forms of copyright protection there is protection in characters. If you have a sufficiently well-defined character, the character gets protected. And so the issue becomes, if a user enters a prompt and out comes Snoopy, is that copyright infringement? And did the model developer do enough to prevent the output being Snoopy, or was that really on the end user? So they're really interesting, fascinating issues in this area that I think will get resolved over time. I don't think they require a change in secondary liability or direct infringement law. The other types of claims, as I mentioned, and the final one that I will cover is DMCA claims. These claims are almost in all the complaints, and there's good reason for that. The damages are calculated per violation, and you don't need a copyright registration to pursue them. And they can go up to $25,000 per violation. And so you can get into astronomical damages very quickly. But the issue with those types of claims and what we've seen in the motion practice addressed to them to date is that they're relatively weak claims because they're hard claims to prove, because there's a requirement of they call double scienter. And what you need to show as a plaintiff that there was intentional removal of copyright management information, which in and of itself is very difficult because the way these models work, they're just ingesting content and they're not stripping out, certainly not intentionally, copyright management information. So that's a tough thing to plausibly plead at the motion to dismiss stage. And the second issue, the second requirement is you need to show ultimately that the removal was done with the intention to induce or contribute or facilitate infringement. And so those are two tough hurdles to pass. And to this point, the plaintiffs have been unable to pass those hurdles, and those claims are being dismissed. You certainly can't rule out a viable DMCA removal of CMI claim down the line, but from what we've seen so far, that's been a stretch. And so that's kind of the bird's eye overview of where we are in the litigation. The takeaway should be that it's relatively early days. This will take quite some time. And the big ticket issue is the fair use issue. And that really is going to be the driver of the outcomes of so many models. And it's a wildly significant issue, I think, for technology generally.
So we've talked a little bit now about copyrights. I think it's important to talk about some of the other IP rights that might be affected by the use of generative AI. So something I'm heavily focused on in my job is trade secrets. And trade secrets, along with copyrights, are considered to be some of the biggest risks when companies are using these models or even creating these models. So I'll bring up a case actually that really surprised me. It came out in August, and it's out of the 11th Circuit that it's CompuLife Software versus Newman. And in this case, we have a plaintiff who is an insurance company and put together a series of insurance quotes, made them available publicly online. And you have a former employee who went, scraped the data, scraped all of the insurance quotes, a massive amount actually, and set up a competing service. So CompuLife filed a lawsuit and said that its trade secrets were misappropriated through the web scraping. And the reason I'm bringing that up is because this is the most common way to get information to create and train these Gen AI models, is through massive amounts of web scraping. So even though the individual insurance quotes were found to be public, the compilation of all of the quotes, the court said it would be nearly impossible for a human to obtain all of that information, his or herself, through the website, that this could only be done through an improper means of web scraping. This is the only case I'm aware of that's like this, but the court did find trade secret misappropriation through this type of information gathering. So this might become a new issue now in the creation of Gen AI models. So kind of on, moving from the creator side to the user side, there was a lot of press about a year ago about a tech company whose employees, they sat through some confidential meetings and then went to a tool like public chat GPT and input the information and then asked the tool to create a summary and maybe some slides. So what happened there, they took confidential information, trade secret information, and used it as an input into the tool. And then because of that input, the information could be publicly shared. Now, we've discussed that doesn't mean it's stored in a library somewhere and you can just recall the information. But if you're looking at the licenses and where the information is going, it's certainly in a public tool being used by the tool creators to retrain their models. So it's being made available to third parties without an NDA. And, confidentiality is one of the requirements of a trade secret. Another requirement is that you exercise reasonable efforts to keep the information a secret. So allowing third parties to access your info with no restriction might not be considered a reasonable effort to maintain your trade secret. So as you can see, inputting the information, inputting trade secrets into public tools could cause a public disclosure or could erode your trade secret program and cause you to lose the trade secrets. The other risk is if you have an internal tool, so many companies will negotiate for an enterprise model, which means it's your own customized version, or you have your own customized security, or there are special things that apply just to you, like your information isn't retained, it's deleted after a certain period of time, it's not used to retrain, etc. So you can set your own parameters. Even when you have a scenario like that, if you're using inputted information to retrain your own tool, which means all of the information stays within your company, it's not going to third parties, you still could possibly be at risk for losing your trade secrets because you might lose access control. So if you have a very important trade secret within your company and every single person in your company has access to it, that also might not be considered a reasonable measure to maintain your trade secret. So loss of access control. I'm not aware of any situations where a user actually gets someone else's trade secret as an output and then becomes liable. That doesn't seem likely to me. But if there were an output of a trade secret, I think the question is then, does it become public for whichever poor company had their information spit back out on the other side? But as for ownership, trade secrets are unique. If we're looking at patents, the patent office has said human author required. If we're looking at copyrights, human author required. But trade secrets does not have that requirement. So there can be information that is outputted to a user in response to a prompt. That information can be used by a company or combined with its business information. There's no prohibition on that kind of use becoming a trade secret of the company, so long as you meet all the requirements of confidentiality, value, and reasonable efforts. So
that is a really fascinating distinction there, of which I was unaware, that there is no human authorship involved in trade secret. That's not a requirement, and a very important one. I just wanted to take a moment to invite the audience, as I should have at the beginning, to throw any questions they might have for our panelists or about AI generally into the Q&A function. I also wanted to introduce my colleague, who is the co-chair of the Intellectual Property Law Interest Group, Daniel Hofilena, who has joined us. So please, if you got questions, throw them in. And I'm going to follow up on Kerri's remarks with a question. It's not the use of the data lakes or this web scraping or collections of data which are involved in artificial intelligence programs, or the functioning of the output of artificial intelligence programs. There's an ancillary set of problems there with privacy law regimes, right? Because when you're scraping data, I mean, of course, one tries to keep one's PII off the internet. That doesn't always happen. There are hacks and such. So how does privacy law factor into the concerns that we have, everybody has suggested we might have about artificial intelligence programs?
Well, I mean, Miriam, privacy, the data lakes would be subject to this, obviously the limitations of the regulatory environment, whatever jurisdiction you're working under, and that can be particularly onerous if it's GDPR or CCPA, or one of the more forward-thinking jurisdictions in the United States. And that, so the data lake would be subject to, to purpose limitations as articulated in the statutes. You'll need to be able, if you're storing the data and it's got PII, you're going to have to be able to answer delete requests and find and produce that information. The consent, any kind of consent that's required would have to be obtained and adhered to. And so I think it probably, operationally it adds complexity. I'm not, in one of the other panels can comment. I think it adds operational complexity. I'm not sure that it changes things.
That's very good. Sorry, Kerri, may I take this opportunity to introduce our fourth panelist who just joined us, and then we'll come right back to you. Dale Cendali, very nice of you to join us. Dale Cendali is a partner in Kirkland and Ellis's New York office and firm-wide head of Kirkland's copyright, trademark, and internet practice group. She's argued before the Supreme Court and won the Harry Potter lexicon trial for J.K. Rowling and Warner Brothers. IP360 named her one of the 25 icons of IP who have made an indelible mark in the IP area. And the National Law Journal selected her as one of the 100 most influential lawyers in America. She is co-editor of the ABA's Copyright Litigation Strategies Handbook, and for many years has taught a course on copyright and trademark litigation at Harvard Law School. There's also a course called Copyright X, which I very much enjoyed taking there. Would you like to give some overarching remarks about AI, or do you want to just dive into the conversation, whichever you prefer?
Well, first I want to apologize to the group. I was in a mediation that was supposed to be over, but you can't control that sometimes. So no discourtesy intended. And I don't know what people have said. Did anyone talk about how the current AI situation is not too unlike what happened 20 years ago with the rise of the internet? People talk about that?
No,
No.
it's
So
all
I-
yours.
Dale, I started by framing it as being similar to what happened with the mass digitization of books that led to Google Books. And
Yes.
alluded to kind of the Betamax cases, but that otherwise we have not addressed that.
Yeah, so I was just thinking about, circa 1995, 2000, when the internet became very popular. People were excited by it, unclear about what it meant, unclear about what the law meant. And there were a lot of competing thoughts out there, like there shouldn't be any commerce on the internet, that IP laws shouldn't apply to the internet, and some pretty radical things that turned out not to be true. There also was a lot of discussion that existing law couldn't be used to deal with internet issues, and there had to be a sui generis law. And to some degree, some of that came about, right? We ended up with the DMCA to deal with some things, but we also ended up with recognizing that copyright and trademark law and others are malleable enough to deal with that, whatever the new technology is. And I wouldn't be surprised if we end up with a little bit of both. There could be specific legislation, some of which the panel might talk about. There seems to be a certain amount of bipartisan interest, for example, in deep fakes type of legislation. But I don't know if there's going to be a sweeping overall thing to respond to everything. I also don't know, everybody's very keen on the idea of maybe some of these many cases that have been filed will solve all the problems and make everything super clear. But if what's passed is prologue, we know, especially in fair use, the concept is that it's very fact specific. So the facts of one situation where there could be severe market harm and keen commercial use may lead to potentially a different result than in another case where there may not be market harm, or the use could be for research purposes. We don't know yet, but what we do know is that we have to make decisions and advise clients based on our best judgment and not be afraid of that, because the genie is out of the bottle. So that's my overriding remarks. I don't want to take any time. I'm not convinced that things are going to be blanket yes, blanket no. I suspect that it's going to be a more nuanced discussion as we work through a lot of these legal issues. And I'll leave it at there so as to avoid a monologue. But if, Marianne, you end up wanting me to talk about some of that PTO stuff at some point, just ask me and I will.
Sure. We would love to hear about that. I'm going to pick up on one thing you mentioned because everybody else has mentioned it. Fair use, a doctrine created by Justice Story in the 19th century. How is it that so much seems to rest so much, everybody's talking about fair use in this, a somewhat, some might think an antiquated copyright doctrine in the context of artificial intelligence. How's it become so important?
Well, I mean, I'll just start with it. It's just that it's the doctrine that applies if you are making use, if you're making a copy, it doesn't have to be a copy, any of the, could be distribution or display, or if you're using one of the exclusive rights of the copyright owner, and there's not a debate that something was independently created, then a typical defense or a defense to that might be fair use. And so that's why it applies, because often in some of these cases, there's not a debate as to whether there was copying. The issue is the legal implications of that. And that's why fair use applies. And you're absolutely right. I mean, Justice Story tried to synthesize common law, and then the Copyright Act of 1976, which is still the new Copyright Act, codified it with the 4 fair use factors that shall be considered, but are weighed under the judgment of judges as to how they might apply in a given case.
And I will just add that copyright law is not designed to protect authors. It's really to forward the progress of science. And so the fair use doctrine is really integral to that, to see if a use is actually going to progress science. And so it's the core underpinning of the Copyright Act, in my view. And it's also, since copyright law is a kind of a strict liability tort, it's also one of the principal safeguards of the First Amendment. And so there are lots of very fundamental issues underlying the fair use doctrine.
And I just tack on to that, onto both of those comments, and sort of removing it from any kind of scheme of liability. If you look at artificial intelligence, what it's doing, there's in some manner, it's totally consistent with the interest of the Constitution and the Copyright Act, which is to promote authorship, not authors, and not necessarily human authors. And the potential for, billions of images and new text and original types of creations lies with AI. So it's and one thing that Dale commented on, which I thought also was very interesting, is that I think that part of the activity that was described by Joe, all the cases and the pinch points of activity is part and parcel, because in some sense, the Copyright Act is able to absorb those kinds of disputes. We can't absorb disputes relative to digital replicas because we don't really have a law right now that completely covers it. And, as the Copyright Office explained. But as Dale said, it's at least it seems to me that the cop is as weird as a lot of this these happenings are, the circumstances, that the act seems to be very flexible. So.
Since this is the American Society of International Law, I thought we might perhaps address the question of the potential consequences of the differences between the United States intellectual property regime with respect to artificial intelligence and the way AI, I think Kerri referenced the EU Act early on in her introductory remarks, the way AI is regarded or treated legally in Europe or China or elsewhere.
I can give an interesting example of this. Marianne, you asked a little bit ago about data lakes and how this might interface with privacy, but there's another law that was recently enacted in Europe. It's a companion to the EU AI Act. We have the EU Data Act, and this is, I think, going to have an effect on use of data to train models and then protecting models. So the ownership and trade secrets could be at issue. So the EU Data Act, which will, it's in force now, but it will be enforced in a year, in September of next year. And this allows users of connected products and related services to request copies of the non-personal data that they generate when they're using these connected products. So some of this data that tech companies are collecting and then using, to train models, to retrain them, fine-tune them, et cetera, could now be subject to the act if they're doing business in the EU or they have users of their products in the EU who are requesting the information. So there are a few things that might touch on this, but one is once this is enforced, you're going to need, as a company who collects information, permission from the users whose use creates the data. And we're talking non-personal data. You'll need their permission to use it or share it with a third party. So now this sort of turns the regime on its head, where we had a system prior to this that looked at, the owners of the data as the ones who collected it. So now it's turning to the creators of the data. In addition, the EU Data Act has very few protections for trade secrets available. So just because your data is a trade secret does not necessarily mean you can refuse to hand it over to anyone who asks. And those who ask can also share it with third parties. So we may have a situation where your data, and this only pertains to raw data, pre-processed data, and some other information, but aggregated, if someone were to collect a lot of this data, you will probably be able to gain some really interesting insights into the users of the data and possibly into these models. So that's just one example, I think, of international laws that are really going to bleed over and affect U.S. companies. But, we also have international cases about, ownership of copyrights. I think one of my co-panelists was going to present on, we had something in China and something in Germany recently.
Yeah, as to China, and just, it's a reflection how different jurisdictions can treat the same issue differently. The question arose as to whether, in the context of a plaintiff in China suing on a photograph that was created, or an artistic creation through the use of AI, and the defense was that essentially that it wasn't, that the plaintiff didn't own the image because the image was created through AI. And the court, in a very, what I would call, optimistic and exciting, to me at least, in a good way, with arms open to new technology, said, and going back to those choices that I mentioned before, that range of artistic choices, albeit that a machine ended up creating the image, the artistic choices were a fantastic instantiation of artistic creativity. And this person owned the image just like they would own it, their painting tools or their camera, or, the photograph that was created by the camera, that this is no different. And it was a wonderful embracing of new technology, contrasted with the kind of ruling that we're getting, or at least the tone of the rulings that we're getting out of our Copyright Office, which are very cautious and protective, and almost reluctant to confer ownership to this type of creativity, cautious about making anything other than a wooden comparison to cameras and so forth. So maybe not a striking difference, Marianne, but you see this difference in attitude across the oceans, and we all thought it was sort of interesting.
Sure. I mean, the United States does not have a right to be forgotten, which exists elsewhere. for example.
Yeah.
So we've got a couple of really interesting questions, and please feel free to throw more in the Q&A. So I'm going to take a little liberty and rephrase slightly the first question. For an artist, what can be done to prevent others from using one's content? Is there a safe space from web scraping, or are we simply sort of are you a sitting duck because you're on the internet? Or is it in some way related to the terms and uses and service provisions that of the site that we post to, that we tacitly might agree to?
I can take a stab at starting to answer that. This is a really, really difficult issue, especially because of the way that Gen AI models ingest and arguably transform and use the information. So you have companies who go in, they use web crawlers, they scrape the information. It could be large amounts, could be smaller amounts, could be transformed. And you're really left with copyright claims in many instances to protect yourself, but the information as it's copied may not be protectable. It may be individual facts in a database. It could lack expression. You may not have enough copying to actually make that claim, or the copying could be a fair use. So there's been a lot of cases on this trying to stop this scraping behavior, and then a lot of failures because it's difficult to prove the copyright claims. So many people think, okay, well, I'll alter my terms of use and I'll say, this isn't allowed. You can't copy my information. But the issue is when you get to court, oftentimes the breach of contract claims are preempted by copyright law. So you're back in the same position you were in. And copyright preemption is actually quite a bit broader than the protection you might get from copyright law. So even a lot of creative claims that people have tried to make have been preempted, and then they're left not able to show copyright infringement. So some things that are left, just in my personal opinion, you could do a couple of things. One might be there are federal laws. So federal laws, of course, would not be preempted, like the Computer Fraud and Abuse Act, that maybe you could take advantage of if you try to use security tools like the CAPTCHA technology that proves you're a human. And there are other companies that have technologies that try to prevent web scraping, and they usually don't last long. Companies figure out how to execute their attack and they can get around it. But when they do that, then that might give rise to a Computer Fraud and Abuse Act claim. Another, just a creative thing that I heard some companies are trying to do is there is a file on web pages. It's called robots.txt.
Yeah, right.
That instructs automated web bots on how to crawl the page, what kind of bots are allowed to access the information, which ones are allowed on the site. And even though this is optional, there's some thought of trying to incorporate that into the terms of use. I haven't seen any cases on that, and maybe my panelists are aware of successful enforcement of that. But the trick is to get a claim in there that is not preempted by copyright. It has an additional or different element to it. So that's really all I have as far as ideas go, or what I've heard. But I don't know, maybe my co-panelists have some more information.
Well, feel free to jump in, but I did want to go back to Dale was going to offer to talk about the PTO, which we really haven't mentioned. We've talked a great deal about copyright, but we haven't yet really talked about the role of the Patent and Trademark Office with respect to AI. Do you want to say a little bit about that, and then we'll go to the rest of the questions?
Sure. And I think Kerri did a great job at explaining, put up your beware of dog sign. Maybe it'll help maybe it won't, but it's better than doing nothing. I think people would say if that's a concern of yours. But on the PTO side, which is the Patent and Trademark Office, because we're often talking about copyright issues, I just thought it was interesting because it shows how ubiquitous the issue is. I don't know about everybody else, but it seems like you can't go into any context without people talking about how AI may be affecting their industry, whether it's writing of marketing copying, whether it's students' exams not being generated or papers by AI, whether it's artwork, fill in the blank, everybody is talking about it. And one of the people or entities that are talking about it are the Patent and Trademark Office. So I find that interesting to begin with, because in April, they issued a notice, April this year, of guidance saying that there's some things that you should think about when you're using AI to potentially fill out your trademark applications. And I think that's interesting because already the government's thinking that maybe people are going to use AI to fill out their trademark applications. So that's an interesting epiphany to start with. But where do they go from there? Where they go from there is a set of guidelines that tell people that you have to make sure that you just don't delegate all this to the AI, especially when it comes to specimens of use, that you end up making sure that they aren't hallucinations and that the use actually reflects how the product is being used in the real world, and that's a concern. And there's also a desire that there be a real human signature that vouches for everything, that holds it accountable, just like what John was talking about, some of the ownership issues with regard to AI and who's the creator and who isn't the creator and who can own the copyright. There's just concern in a different context that the use of this very wonderful, in many ways, tools of AI also need to make sure has human oversight and supervision to make sure that you get the benefit without getting into that benefit some of these problems. And I just thought, in a very microcosm, this shows us some of the debates and that are going on, and reminds us as IP lawyers that if you are going to use this to help you with your trademark applications, you need to continue to supervise and be very careful, especially about the specimens of use.
So that point really dovetails nicely, or leads nicely, to one of the questions that has been posed by the audience about accountability, precisely that. And of course, in the field, in a totally separate field of autonomous weapons, the point of human decision-making is really critical in determining whether or not an autonomous weapon involves a violation, for example, of humanitarian law. Totally different. But the point at which the human being makes the decision is very critical in a number of legal analyses. The question here is, given that artificial intelligence is not itself, it's not a body we can hold accountable, who do we hold accountable for breaches of privacy, data privacy, copyright infringement, etc.? Do we hold the creators? Can you hold the creators of an artificial intelligence model or software program, or the user of the AI program, accountable? The person says that they're thinking in particular of data breaches, but also about deep fakes.
Well, I will just jump in and say yes to all the above, depending upon the circumstances. I think Dale said that existing law in a lot of cases is actually well equipped to kind of deal with these issues. And on the copyright side, I think you could certainly hold a model developer liable if the model was developed in such a way that made it highly likely that infringement or issues would result and didn't take reasonable precautions and didn't have a kind of a general purpose capable of substantial non-infringing uses, you could definitely think of a model. And the one that somewhat comes to my mind is, I think we were talking about it yesterday, so one of the panelists, if you trained a model solely on Beatles songs, and then the output sounded a lot like a Beatles song, that liability, to be very good arguments, is on the model developer. Conversely, if you have a general purpose model capable of substantial non-infringing uses, and it's the user that actually manipulates it in a way to create infringing or harmful output, in my view, the responsibility for that should be on the end user. And so there's lots of law in this area that I think would be equally applicable to AI models.
That's
I
great.
also, just
Please.
to touch on this, that like anything else, it's complicated, right? Because you can see, and I'm just talking agnostically here on the law professor, like I'm not advocating what I think should be right or anything like that. But you can certainly see the problem, going back to where I started with policing and dealing with the internet, infringement on the internet. It's difficult to go after lots of small infringements on the internet and find individuals. So you can understand why people might want to try to find a deeper pocket or someone to be able to be responsible. But are they really responsible is the question. As you indicated, Joe, is it like the Betamax case where you provide technology, but it may not be infringing, you may not be inducing people to infringe? And there's a bit of debate about volitional conduct and how it exists, but are you yourself acting? Like if I go on something and I go out of my way to do some mashup of different copyrighted characters, and Dale, am deciding to do all that, should Dale be responsible or should the company be responsible? And it reminds me again of the debate for some of these websites. Are they seen as newspapers? Back we were dealing with the internet debate was, should they be treated as newspapers responsible for the content published, or should they be treated more as phone companies that are not responsible for what people might say on the phone lines or use the phone lines for different purposes? And depending on how the facts may play out in a given case, you could see it differently. And this could be an area where there could be congressional legislation, I suppose, if there's a need to protect certain types of activities. Like you were talking, Marianne, about bombs going off and things like that. That there could be different laws on some things than on other things.
We mentioned volitional conduct. I think we can't underscore enough that prompt engineering is becoming a really popular and in-demand field, and we have some really talented people in this field, and they can take advantage of known like the size of a training set, complicated edge case detection, things that they know if they prompt in a certain way and they keep at it, they can elicit certain information. And I believe this was one of the topics, was it in the Getty Images case or one of the cases where—
New York Times as well.
Yeah, where the attorneys and the teams had trouble reproducing the result because the prompter was allegedly so talented. But we also have model providers that have terms of use. And I'm seeing this a lot in contracts that I'm looking at, that I'm receiving from these providers, where they prohibit that kind of use. They prohibit intentional solicitation of information. And, if you do that, they may refuse indemnity, et cetera. So I can't underscore enough that there could be ways, at least right now, until the technology gets better, that you can cause an output. For example, you enter, the text to an entire book, and you ask for some kind of action to be performed on that book, and then it comes back, you can probably have infringing content that comes back, kind of depending on what you do with it. So a lot of it rests on the user side as well.
Thank you. We've got a couple of questions. One is very, very general, but very important. And so I'm going to ask them both, and you can, anybody who wishes can pick up one or the other or both, and then we'll move to concluding remarks. So the general question is, are there regulations for generative AI use that account for environmental concerns, especially given the ongoing effects of climate change? And what about the kind of access issues that are involved with AI? In other words, the kind of stratification socioeconomic that occurs because not everybody or a large part of the world does not have the access to technology that those who regularly use AI have, and does that create an untenable inequality? That's the first question, which is very broad and very has a lot of ethical implications. The second goes back to the fair use issue. Is fair use also applicable to potential trademark infringement by generative AI in the US? And does anyone know whether or not the USPTO itself uses AI for patent and trademark examination? Are there any guidelines? If so, I like that last question.
I can speak to the last one. I'm not as sure about maybe the first one, but I heard Kathy Vidal speak just a few days ago, and she is talking about how the USPTO is being encouraged to use and experiment with generative AI. They have a very safe and secure sandbox, so they have their own enterprise models, you can imagine, so there isn't risk of that information kind of getting out there. But they were looking at things like classifying inventions according, their respective art units, and gathering prior art, for example. So I am aware of that. As for trademark fair use and infringement, maybe just one thing to keep in mind: trademarks, the infringement comes in how you're using it, or if you're using it. So I guess it really depends on the user there, but I'll let someone take it away with the rest of those.
Yeah, I feel like Joe and I should arm wrestle for this particular, we both do a lot of trademark law, but there's different kinds of trademark fair use. There's descriptive fair use, like, if you need to say, use a trademark because that's an ordinary name for something, just because someone has a trademark can't stop them from that. And sometimes there's nominative fair use, that you have to use a trademark in order to, if you're trying to refer to somebody else. I think more of these cases, and you've seen this in, I think, some of the cases that have been filed so far, are more concerned with trademarks appearing and the results of generative AI creating, where the trademark owner doesn't have any control over that usage and may not think it's being used correctly, or could give the impression that there's a tie-in in some way to their company when they don't wish there to be. And that is not a fact pattern that fits neatly into either of the descriptive fair use or the nominative fair use paradigm. Joe?
I completely agree with that, Dale. I've got nothing to add. You won the arm wrestling contest.
Are you in the next one?
Well, perhaps with respect to the very large ethical questions raised, as everybody makes their concluding remarks, taking a couple minutes to sort of emphasize the points you consider most important in this, we've covered a vast array of issues. Maybe you could consider the ethics of the use of AI in your concluding remarks. Why don't we start with you, Kerri, if you don't mind, since you went first?
Yeah, sure. So I guess my conclusion or my takeaway is, okay, you know about all these risks, and whether you're in-house or outside, you really need to be armed with some practical ways to operationalize mitigating these risks. And, as an in-house counsel, I'm almost singularly focused on that. What do we do with this? How do we read the tea leaves when we have cases pending? We don't know what to do. So, touching on ethics, you need to decide, are you going to have a policy with respect to responsible AI? Do you have a responsible AI committee? Are you reviewing and evaluating use cases, tools that come out to you, and what standards are you going to use for that? With respect to trade secret protection, you may want to consider policies on what kind of information that is entered into the models by your employees. If you have a system of ranking your information or identifying trade secret information, depending on how your information is it used to retrain models or not? You might want to put guardrails in place on, number one, whether or not employees can use public tools versus enterprise. And for the enterprise, what kind of information can they enter? And then in the copyright and the patent realm, I think we really need to think about whether we adopt some kind of way to document how we're creating things using these Gen AI tools. So as a quick example, if you're creating code, there's a very popular tool called GitHub Copilot. And GitHub Copilot, as you're coding, you can either ask it for code and it will come up with something, which is pretty straightforward, or it goes into predictive mode. So as you're coding, it tries to predict the very next word, thing, number that you're typing, and you can hit tab, 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 and you can accept that. Is the AI doing that, or are you? Who's creating that code? And how do you prove it? So you submit your registration for your copyright. Is your registration Swiss cheese, where you have little pieces that are not copyrightable and other pieces that are? And if the copyright examiner calls you, how can you explain which pieces were created by Gen AI and which ones weren't? So I don't know if the Copyright Office has addressed that in full detail, but we'll certainly get more information as we go. But the larger issue is when you get into litigation, of course, the other side will attack anything that has any involvement with Gen AI. Are you prepared to argue that you have a valid copyright? How can you prove the scope of your copyright? Or is it more damaging to have evidence of exactly what you did? I think as a company or as someone advising a company, I think it's smart to come up with some near-term solutions. And for patenting, how were Gen AI models used to co-create or partially create inventions? I think, need to have some kind of documentation in that regard, but how do you do it? What detail do you have? So, think of the practical side of how we protect ourselves and mitigate these risks.
Thank you. John?
Yeah, sort of at the very practical, and then just a higher level comment. At the practical level, I can just say that, I've been spending the last months, year or so, really trying to understand the risks and the properties involved in AI as it maps to my practice, which is a lot of transactional work. And I would just say that, that's understanding the groundwork in terms of how you put together certain representations, warranties, and covenants is really important. And it continues to be a struggle for me. But that's, sort of to Kerri's point about how to, operationalize it. For me, it's really been, read the cases, understand it. I'm not a litigator, but boy, they're relevant for understanding what's at issue in these transactions. So that would be number one. At a higher level, Dale talked a little bit, and then Marianne, you alluded to, accountability and human decision making. And there, I would just remind everybody that there is an onslaught of legislation coming. It's not strictly in the IP area, and we don't have time, nor am I capable to really comment on how that's going to bleed into IP, but it will. The laws relating to transparency, accountability, interpretability, mitigation of bias, all those things, and most importantly, automated decision-making are already part of the crazy quilt of US law. And it's going to be, as much or equal to or greater than, the burden on transactional lawyers and others, in exercising and keeping compliant. Part of that, I think, will bleed into some of these questions that people have been asking about how, the various liability schemes end up, because I think some of it's going to be, fall into these legislative determinations. You can already take a look at Colorado. Obviously, people should be looking at the AI Act, where everybody's taking their lead. So that's what I have to say.
That's great. Joe?
Those are all great points. I will just say, there's a long-standing cliche that technology greatly outpaces the development of law, and I think that is incredibly true in this area. A lot of the issues that we're debating about fair use and use of in-copyright material to train a model, those are issues that from a technological standpoint should have been addressed 8 years ago, 9 years ago, and all this stuff was done. And that the models are developing at such a pace and the technology is developing at such a pace that the law is going to be extremely hard pressed to keep up. And there's going to be a huge desire, because the impacts will be so transformative and significant and unpredictable. There will be a huge desire to kind of legislate, and I think courts will jump in. And whether or not they're going to do more harm than good is a very significant issue, because there's going to be a huge instinct to modify the law to control this in some way, and to use kind of an overused hackneyed metaphor, the toothpaste is already out of the tube. So it's going to be very interesting to see how this plays out.
Great. Thank you. Dale?
I was just thinking about the question from the person who seemed to be concerned about, I think it was about unequal access, or concerned about other nations and the like. And I guess I have two thoughts. I think it's obviously true that nations that are lucky enough to have advanced technological companies like Cisco and others of course that's an advantage. I mean, you're lucky to have people at the cutting edge. I mean, just look at how Kerri was talking today. They're at the cutting edge of all these nuances. But the flip side, or the additional side, I suppose, is that many AI products make it a lot easier for many people to create, who don't have to have a tremendous amount of infrastructure. So those folks could benefit in the ideal world from the technology. So it's a more nuanced, like everything else, way of looking at the problem and the benefits of the problem, because certainly AI will make a lot of things easier. And the question is at what cost, and are we applying the incentives properly of the Constitution? Is everyone being rewarded? And time will tell.
Thank you. I want to thank all of our panelists for what has been a really fascinating discussion, and one which will continue for years, as we indicated, around some very tricky issues. It's a terrific discussion. So on behalf of the American Society of International Law, the Intellectual Property Law Interest Group, I'd also like to thank my co-chair, Daniel Hofilena, calling in from Manila. I'd like to thank everyone for joining us. This program was recorded and will be posted to YouTube. Thank you.
Thank you. Thanks all.
Bye all.
Thank you, everyone. Thank you, Mary Ann, for a wonderful panel, and all the panelists.